and a warm welcome. Thank you for joining me today on Viewer Exclusive. You know, this program is packaged exclusively for you. So today, we're going to be looking at the tribunal. We know that the elections have long ended in February, right? Inaugurations, the new government of the day has been sworn in and have gone full into governance. But the opposition parties, notably PDP and the APC, are not in agreement with the judgment passed by the Presidential Election Petition Tribunal on the 6th of September and have therefore continued on an appeal. Now, what does this mean? What does this mean for Nigerians? What does this mean for polity and governance? To help us answer these questions, I'll be talking to an expert after the break. My name is Chinonso Pam. Please stay tuned and join us in the conversation right after the break. Thanks for staying with us. This is Viewer Exclusive. So before we went on that quick break, I told you we were going to be taking a look at the appeal, right, that the opposition parties have made on the judgment on the Election Petition Tribunal. I'm being joined live in the studio by PIUS DANBA, a legal practitioner, here to help us answer questions that are boggling us. Nigerians want to understand what is happening with the appeal. Thank you for coming on this show today.
Thank you so much for inviting me here.
Yeah, you're welcome. All right, so let's go straight into the matter, right? Judgments have since been passed.
Yes.
September 6th,
yes.
Right? And there's Nigerians are feeling Nigerians are on both sides of the divide.
Yeah.
But on a general note, how do you think that Nigerians now perceive our judiciary? Has it built their confidence based on Nigerians who tell themselves, we are the eyewitnesses. We saw what happened during the elections?
Well, you see, the way the judiciary works, people need to understand so that we don't make wrong assumptions or live with a poor understanding of what is going on.
Okay.
A lot of Nigerians are not really familiar or conversant with the way the judiciary works. So that's why you see a lot of people shy away even from going to court or anything that involves a court at all. But the courtroom are public place for judicial determination of dispute, especially like the election dispute we're talking about. If something has happened that you feel is wrong, the courts are open for you to come and ventilate your grievance, and state exactly what is wrong with the process, what are the issues that you observe, or what are the things you have seen, and then bring your evidence. And at the end of the day, the court will do justice to that. But the challenge that I see as a legal practitioner is that more often than not, people are not coming forward. When an incident happened, let's say in a particular locality, and it's just like you on virtually on daily basis we see events happening, and when you make call for people who witness what transpired to come and state what they saw, people will not be forthcoming. And the courts are mandated by law to only work with the evidence presented before them. They cannot assume, they cannot make use of information that is flying on the social media or what they watch on TV or whatever. They have to work with the evidence on record presented before them. So if your case is without hard evidence that is in accordance with the law before the court, then invariably you cannot go home with the judgment you are expecting.
So you, as if I get you right now, I bring the case. I am the petitioner
Yes,
right now.
yeah.
It's mandated on me to bring my evidence.
Yes.
The court does not do that for
The
me.
court does
So
not
if
do
I
that,
fail to bring the evidences that can prove,
yes,
then it is up to me I have to take the judgment of the court, because the court will have to work based on the
exactly.
judgment.
So once you are unable to prove your case, and that is what the Court of Appeal have decided in most of these petitions, that look, these petitioners have invited us to look at their petition. We have looked at it, and then the evidence that they have called does not establish the complaints that they are talking about.
Yeah.
So when you allege, for instance, that you won the election, but someone else was declared, you are expected to bring results that shows you won the election, or you should bring the ballot papers that will be counted, and then the court will determine that indeed you won the election. So what in the absence of such evidence, there is no way the court can reach a conclusion that you won the election.
You want. Okay. So now in the case of this presidential elections tribunal right now, we're looking at the APC and the PDP and the Labour Party. They have brought forward their evidences, but now they are not in agreement, because I'm guessing that they believe that whatever evidences they have brought forward should prove beyond a doubt that either of them won these elections. And now that they have not agreed, they have appealed. Explain to us and explain to Nigerians, benefit of those who do not understand. What does it mean that they have appealed their case?
So you see, an appeal is basically inviting the appellate court, now in this case the Supreme Court, to look at the judgment that was delivered by the Court of Appeal, and then look at the evidence on record. Because at appeal level, you are not expected to introduce new evidence. So anything that you don't have on record cannot come in again. That is by law. It's no one's making, is how the law is framed.
So you should do all your homework at
the trial court. So now at this appeal level, the Supreme Court will be invited to look at the record, to go through the judgment and then go through the records and see whether there are documents that the Court of Appeal was supposed to consider and it did not, or there are witnesses that the Court of Appeal was supposed to consider their evidence to reach a decision one way or the other, and they did not. So all of those things will be looked at by the Supreme Court, and then from the record, the Supreme Court will be able to determine, was the Court of Appeal right in giving judgment dismissing these petitions, or the Court of Appeal was wrong in dismissing these petitions.
Is this not based on the same?
Yes, it's
the
going
same
to be.
system?
Yes, it's going to be.
So how is it based on the same system?
Records. The thing is that, and it's not like it is not possible to find errors from the record. Okay. Now there are cases, we have seen a lot of cases where one court will give judgment, in favor of a person, and by the time it goes on appeal, the appellate court will look at the records and find out that, oh look, there is a vital piece of evidence that you did not consider while giving your judgment, which if considered may change the outcome of the judgment one way or the other. So it's not new, and it's not going to be strange if the Supreme Court look at the appeals and give a decision that is different from that of the Court of Appeal. But it's going to be based on what they find on record, because the court will have to work with the evidence that they can see on record.
Okay, so we'll come back to this.
Right.
But as a legal practitioner now,
yes,
we want you to make a defense for the judicial system.
Yes.
Because let me land. I want us to look now at the tribunal, the judgment passed on the National Assembly petitions and the presidential election petitions.
Yes.
Panels have come to argue that pre-election matters were made rubbish of in the presidential election petition tribunal. But they were the issues that were used to pass judgments on the level of the National Assembly petitions. Is that how it is supposed to go, or what happened there?
Well, you see, the issue of whether a matter is pre-election or post-election, it's elementary, it's clear, all the things, all the activities that happen before the conduct of election are pre-election matters. And of course, complaints that are tied to the activity of the actual conduct of election, the balloting and the declaration of result, those ones are considered as post-election matters that should go to tribunal. And the courts have been consistent that the issue of nomination of candidates are all pre-election matters. And so complaints relating or tied to the issue of nomination are always treated as pre-election matters. Now, you see, you have to understand that the Court of Appeal, it's between the Supreme Court in the ladder or the hierarchy of courts. The Supreme Court is above all courts, then followed by the Court of Appeal, and then you can place the tribunals. Now, the decision of the Court of Appeal, is superior to that of tribunals. So if the Court of Appeal have decided that nomination of candidates is a pre-election matter, it means that by judicial precedent, tribunals will now be complied to follow, or they will be compelled to follow that decision of the Court of Appeal, because in the hierarchy, Court of Appeal is above them. Unless if Supreme Court gives a different decision, that is when the tribunals can also
in this
change.
instance,
So now you have to understand that the way the court works is that it's not like every case that is in court is to the knowledge of every other judge, or every decision that is given is to the knowledge of every other judge. Now, if two matters are pending, maybe one in Court of Appeal and the other one at tribunal, they may not be aware of each other unless the parties in those cases are able to draw the attention of the judges in those cases to the two pending cases. So if a Court of Appeal has given a decision today and your matter is coming up tomorrow, you may be able to cite that as reference so that the tribunal will follow. But where those decisions are already made, maybe they were made contemporaneously, it's not possible for the tribunal to have known this is the decision that the Court of Appeal have just delivered.
And there's no system to feed that down?
Well, you see, that is why you have your lawyers, and the duty of your lawyers is to bring to the attention of the court all of such decisions, because we have what we call law reporting. Now, the law reporting is to report decisions of courts, various courts, Supreme Court, Court of Appeal, even high courts, and the likes, So it is through this law reporting that the lawyers become aware of new decisions, and then they will draw the attention of the court in the matter in which they are doing, so that it will be applicable to their case.
Okay, you have made a case for the judicial system right now, but it still lands on the your lawyers to do their job.
It's important for Nigerians to appreciate, to understand how the system works. Because when you don't know how the system works, it's easy for you to criticize, to complain,
to say this was
condemn,
here,
because you are not really in grasp of how it operates or how it works.
So information is key, and that's exactly why we are doing this, because we want to make people to really understand what is happening, especially in this appeal level. And so the Supreme Court right now is the final
the Supreme Court is the final
whatever decision they make, you have nothing else to say.
Is final on this issue. There is nothing anyone else can do about it, except just to accept the outcome of the decision and then abide by it. So the Supreme Court is final on this issue, and that is it.
All right. So we're going to talk on what this appeal is actually, and what's available and what's obtainable to all the parties. We'll continue this conversation right after the break. Do stay with us. This is still viewer exclusive. Thanks for staying with us. You're still watching Viewer Exclusive, and we're deliberating on the tribunal today, which is a matter that most Nigerians want to understand and want to know what is happening. And I'm still joined in the studio by Mr. PIUS DANBA, a legal practitioner. So before we went on the break, we were talking about how Supreme Court is the final bus stop for judgment. So now explain and take us through the processes of making this appeal.
Well, appeal is simple and straightforward because after the parties have filed their notices of appeal, the next thing is for the Court of Appeal, in this case, which is acting as a trial court now, to compile all the records, compile all the evidence, and forward it to the Supreme Court. Then the parties will make their arguments, based on what is available on the record, before the Supreme Court. That will be the next stage. And then the Supreme Court will reserve for judgment. So in a matter of 60 days, all of this will be over.
So it takes 60 days?
Yes. It's, the appeal will be determined 60 days from the date of filing the notice of appeal. That is provided by the Constitution. So now, as it is, it's just for the Court of Appeal to transmit all the records that is before all of the things that have transpired, all the evidence that were produced, all the papers that were filed, all the arguments, all the papers that were filed in the processes will be compiled and then taken to the Supreme Court for the Supreme Court to review. So basically that is just what will happen, and then the parties will come before the Supreme Court and make their own argument as to what they feel should be the decision of the Supreme Court, looking at the evidence on record, looking at what they have been able to do at the trial court. So once they've done that argument, the Supreme Court will adjourn for judgment.
Okay.
Yes, of course.
So you've been talking about evidence on record.
Yes.
We're talking about the ones that were brought during the trial session.
Yes,
so is there any room for bringing in new evidence or bringing in new witnesses in an appeal?
Well, you see, although there is room, generally under the law, you are not permitted to bring any evidence at all once trial has been concluded and the matter proceeds to an appeal. Now, that is the general position of the law. There is a very, it's only in very rare instance, very rare and special instance
that the Supreme Court
the Supreme Court may allow you to bring in a fresh or new evidence. And before you will do that, you will have to really show the Supreme Court and establish that indeed this situation is really beyond your control. It's not something that you will have, you have to show merit that it really deserves
to be taken in as fresh evidence.
Yes, to give you that chance.
So there's a slim chance that can happen.
There's a slim chance that can happen, but
we're asking. I'm asking this now because of ex-Vice President Atiku Abubakar, who is making demands for President Tinubu's school records from university to be, to be released and all of that. We know the story behind that. How does that play out if he gets these records? Can his lawyers be able to make a case that this be taken in?
The law will not shut them out should they attempt to bring in a new evidence. An application can be made in that regard, but it is for the Supreme Court to decide whether the situation warrants the admission of a new evidence on appeal or not. But generally, the fact that an evidence exists and you were unable to bring it at trial is not ipso facto.
Even if it was beyond your controls, even if you tried and time did not allow.
Well, you see, election petitions are time bound. Okay, so before and let me even say this. One challenge we have is that the moment a candidate is nominated as a candidate of a political party, that is when we should be interested in checking him out to know whether that person is qualified.
Not after election results.
It is not after the person have won election. Because for instance now, the candidates, there were about 18 candidates that contested. Most of those that lost the election, nobody is talking about them. Nobody is saying whether this person was qualified to contest the election or not. You know, so it should be of interest to us all, irrespective of the political party the person is standing election. We should be interested to know, because it's possible that any of them could have won the election.
Yeah.
You know, so why are we not interested in knowing who are the people that are flying the flags of political parties? You know, it is only when the person have won election, then we wake up from our slumber and begin to ask questions, begin to look for evidence and all of that. I think that is not right. The proper thing to do is, that is why the courts have always till the line of classifying it as a pre-election matter. If you have any grievance about the qualification of somebody to contest the election, even at political party level, at primaries level, you understand? We have people contested. I think in the APC we had so many candidates that contested the election. Yeah. You know, the same thing with PDP and all the other political parties. So at that level, we should be able to see people indicate interest to vet the persons that are contesting this election, so that there should be people that when they win the general election, you know, we will be comfortable with them. That yes, this person is worthy to be my president. He has the character, he has the documents, he has the competence and all of that. It is not after the person have won election, then we begin to scrutinize to say, oh, let's go and look at his primary school. Did he
have time limits?
Yes. Did he go to primary school or not? Let us look at this. Let's look at. No, that is not the time to do it.
Talking about that, clarify to us the requirement to run as president, to run for presidency in Nigeria.
Well, you see, the Constitution have made it very, very simple. That all you need is just to have an SSC, or that you have attained a level of education equivalent to an SSC. And what that means is that you don't even need to have the certificate.
Oh, really?
Yes. What it means is that you will have been educated up to that
level.
So, assuming you don't even have the certificate, but you have passed through the school can testify that indeed
you were here in this time.
Here between so period to so period. That suffices.
So why is it a problem right now for President Tinubu's? Why is that a problem? Why is his records now an issue? Is it because he submitted them?
Well, you see, there is the fact that we have qualification requirement, and then we have disqualification factors. They are different, yes.
Okay.
Now, qualification requirements is just to have SSC, you are a Nigerian and you are of age, then you can contest the election. But when we talk about disqualifying factors, there are things that can happen to you that will disqualify you, even though you have met the qualification requirement. For instance, if you you've lost your mind, you are not sane, you know, of course, we cannot have a madman as our president.
Yeah.
You know, so it's a disqualifying factor. Or if you have been convicted before, you know, within a period of 10 years before the election, then involving an offense that deals with dishonesty, then of course you will be disqualified. Or if you have presented a forged certificate to INEC. So that is where some of these things are being
contested. Okay,
Yes.
not about whether that qualifies you to run or not,
Yes.
because I know there's a mix up of that. Oh, your
Yes.
resident, he didn't go to school, he didn't, but that's not okay. So
Yeah.
so now we're clear
Yeah.
on what is going on now.
Yeah.
As we begin to wind down, however, what we can't preempt. I don't know if we
Yes.
can't preempt
Yes.
what will come out
Yes.
of the appeal in the Supreme
Yes.
Court. Now we
Yes.
can't preempt, but let's just play the card, because it's a 50-50. It can swing either way
Of course.
or the other way.
Of course.
Now, explain to us now in detail how this is going to affect governance or polity, because that's our concern right now. Is it going to shake things up? Are things going to continue as they are? Because the government of the day is already in full-blown governance.
Well, you see, I believe that the parties, they know the strength of their case. Those in government and those trying to get in, they all know the strength of their case. They've had sessions with their lawyers. Their lawyers must have advised them and informed them of the chances that they have. So they are fully aware of what may come out from the Supreme Court. And it's just that some of them may not be telling their followers, or they may not be telling Nigerians the truth, that look, based on what we have done, this is what we think may come out, because people are trying, people are trying to see, oh, okay, they don't want to give up, they want to see it to the very end, to see what is going to come out. But I believe that whatever that is going to come out of the Supreme Court, this is not the first time that we have witnessed a challenge about the outcome of a presidential election. There have been several cases.
Yes.
People have gone to court. In fact, there was a time that the Supreme Court almost nullified the presidential election when the former president Muhammadu Buhari went to court. He only lost on in a balance of 4 judges against 3. Three decided that the election should be nullified, and then 4 said no, the election should stand. So you see, we have gone through these processes before, in this country, and the presidential election, except for former President Goodluck Jonathan, who decided to concede and did not go to court. Almost all the presidential elections have been contested in court before, up to Supreme Court, even during Shagari era and all of that. So I don't think it's anything new. Governance should continue as normal, because of course nature abhors vacuum, and then the law also presumed regularity. These ones that have been declared, they are presumed to be there, and that's why you see, even for let's say governorship elections where the tribunal has nullified such elections, the law permits those people to still remain in office until the appeal processes have elapsed. Say, for instance, the judgment that came out from Kanu, sacking the governor, he will still remain in office until all the appeal processes has...
Talking about that now, lastly, before we go, we are out of time entirely. We hope we wish this conversation could continue. As a legal practitioner, would you advise, or what would you say should happen in a case where people have, oppositions have taken the election cases to court, and the inaugurations have gone forward, right? Would you advise an interim in the meantime before the cases are out of court?
Well, you see, the way the law is structured as it is, I think if there should be any amendment, it should be that elections should be conducted earlier, and then petitions should be dealt with before the date of swearing in. Yes, I think that would be more at home with me, instead of let's say putting in an interim government before. That will bring a lot of confusion.
All right, thank you so much, DANBA, for bringing a lot of clarity to what Nigerians should expect in the appeal. We'll have to hope to have more conversations on this as the processes process goes on. Thank you so much for sticking with us till the end of Viewer Exclusive. We hope that this conversation has brought a lot of clarity to the appeal process. My name is Chinonso Pam. Do join me again on Viewer Exclusive. Have a good time. Thank you so much.